for adults item number 1.
The defects have already been complied with. There's no defect in this case.
All right.
May I just, for your lordship's kind appreciation, I think it will suffice if I just place your lordship's, before your lordship, the date chart, my lord, if lordship would see. Here, my lord, in spite of the lordship's order and judgment, my lord, where objections should not be accepted and summarily rejected after the due date, which was fixed by the collector for grant of license. Still, my lord, at every stage when the file moves, objections are being entertained, inquiries have been conducted, inquiries have gone into my favor, in my favor. Still, my lord, objections are being entertained, lords. May I just place the date chart for your lordship's kind of appreciation, lords? Lordship got the date chart, please?
Yes.
On 5/4/2022,
Yes.
application is made by the petitioner for a restaurant on shop by a non-refundable application fee of 1,10,000 along with the bank guarantee has been filed. Then on 8/4/2022, the superintendent is directed the inspector for an inquiry and spot visit to be made. Then on 19/4/2022, the inspector of excise Nagar submitted a report regarding the feasibility of the site. Then on 12/5/2022, my lord, the superintendent, who is opposite part number 5, submitted a report to the collector, who is opposite part number 3, recommending the on-shop, my lords. Then accordingly, the collector issued a public notice, my lord, on 13/5/2022 and called for objections within 15 days. That is on and before 27/5/2022, my lords.
All these are complied.
All
Yes, everything. Last date may kindly be seen. The last date.
The municipal, yeah,
24
again, a fresh inquiry.
my lord, your lordship would appreciate the collector. Sorry, my lords.
The government of Orissa demanded for an inquiry to the opposite part number 3 regarding functioning of the Galaxy restaurant and that if it is registered or the GST.
How many inquiries, sir? The whole
That is
problem.
what he is saying.
And
Endless inquiry, and that way you're delaying the whole thing.
Lordship may direct to dispose of within a target.
no, lordship may, in this particular case, the lordships have directed them to issue the license itself, my lords. The lordship may say, my learned friend, my lord, he's aware of that Gitanjali House case in paragraph 21.
Your lordship may direct the government to.
No, now what has happened, my lord, my
Within
difficulty,
10 days, they
No,
will pass an
no,
order
my difficulty,
without insisting upon the subsequent other inquiries.
20, paragraph 20, your lordship may kindly see, my lords. At page 7.
Right.
There's also merit on the contention of the learned counsel for the petitioner that Srimati Malati Tudu and Jagmohan Tia had filed their respective objections to the public notice on 21st of September and 1st of October 2020 respectively, which were after the expiry of the objection period of 15 days provided under section 20 of the Odisha Excise Act 2008, read with Rule 31A of the Odisha Excise Rules 2017, Rule 3132 states that any objection received after the aforesaid period ought to be summarily rejected. In the present case, the public notice dated 28th of July 2020 and the objections had to be filed by 12th of August 2020. It is plain that the objections filed were belated and ought to have been summarily rejected.
Be that
According-
as it may, the objections have been examined and the report is in their favor. That is that there. So only thing is that government is to take a final decision within a particular period. That your lordship can direct.
And this GST, my lord, which now has been raised by the chairman, my lord, who is objecting throughout. My lord, your lordship may kindly turn to page 20. It's a part of my application which has been forwarded by the collector, my lord. Page 20, column number 7.
Overruled, that objection can be ignored and collected.
And all objections will not have, your lordship would see, my lord, page 20, call serial number 7, copy of the GST certificate, yes. And your lordship knows, my lord, unless I go into business, my lord, returns can't be filed.
Correct.
And the objections are, my lord, the GST registration, the returns are not filed. So unless I begin my commercial trading, my lords, how do I submit, my lord? So only be a nil return, my lords.
Correct.
Your lordship would, I'd only humbly pray, my lord, subject to what my learned friend says, my lord. Your lordship would pass a direction to issue the license, my lord. But otherwise, my lord, otherwise what will happen, my lord, in the garb of these objections, my
In
lord?
other cases, your lord, that type of direction never issued because your
Right.
lordship is always directing them to consider and your lordship can record the observations which my learned senior is saying that this is not required because GST number is there, everything. But the discretion should be left to the government to take a final decision on. Thereafter, the direction directly to the government to issue license will be.
And within the due date, your lordship may
Yes,
kindly
yes,
see
yes,
annex,
10 days. Within 10
within
days.
15 days, annexure 8 at page 29, my lordship would appreciate from 23/5/2022 at page 29 notes.
Yes.
From 23/5/2022 to 2/6/2022. Whatever objections were there, my lord, has been inquired into, my lords. And the last date, your lordship would see the previous
That is
page.
already inquired.
That is already inquired.
That is no dispute. Only thing is that GST number, what my lord is saying that business has not been approved, so GST return cannot be. By observing that, your lordship may direct the secretary to take a final decision within a particular time.
You say aggrieved by the non-grant of a license for an IMFL restaurant on shop under the name and style as simply quotes Galaxy Bar and Restaurant at Nayagarh. The petitioner has filed the presented petition seeking a direction to the opposite parties to process the petitioner's application and grant the license. Paragraph. This court has heard the submissions of Mr. R.P. Kara, learned counsel appearing for the petitioner, and Mr. Devakantamanthi, learned AGA for the opposite party state. Paragraph. It is seen from the narration of events in the petition and the date chart submitted that the application by the petitioner for the restaurant on-shop license was filed way back on 5th April 2022. And in response to various queries and objections and clarifications given by the petitioner, followed by inquiry into the objections raised, the Inspector of Excise Sadar, Nayagarh, submitted a report on 4th June 2022 itself to opposite party number 5, that is the Superintendent of Excise, Nayagarh, that none of the objections were valid. Full stop. This included the objection received from the chairperson of the Nayagarh municipality. Full stop. Accordingly, the superintendent on 6th June 2022 itself made a recommendation to the collector Nayagarh that the petitioner's application should be granted. Full stop. However, another high-level joint inquiry was launched by the commissioner on 13 July 2022. And yet another inquiry on 5th November 2022. Full stop. All these inquiries went in favor of the petitioner, with the excise deputy commissioner informing the department that the building in which the restaurant was being run is in a commercial area. Paragraph. On 24 January 2023, yet another inquiry was ordered only to determine if the petitioner was registered under the GST Act and if returns will be filed. Full stop. Paragraph. Mr. Kara has drawn the attention of the court to the chart prepared by the application submitted by the petitioner, which itself shows that a copy of the GST registration certificate has been enclosed. As rightly pointed out by Mr. Kara, unless the petitioner is issued a license and is able to commence its business the question of filing a GST return would not arise. Paragraph. Mr. Manthi states that if any time-bound direction is issued by this court, it will be complied with. Paragraph. Considering that all the previous inquiries have not found anything adverse as far as the petitioner's application for a non-shop license is concerned, and with the petitioner having a GST registration certificate, the opposite party should now complete the exercise of further inquiries and communicate to the petitioner the decision of the petitioner's application positively on or before 31st March 2023.
Instead of opposite parties, opposite party number one.
Opposite party number. All right. The Excise Department.
Secretary.
To communicate to the petitioner the decision of the government on the petitioner's application not later than 31st March 2023. Full stop. It is specifically made clear that such application should not be rejected only because a GST return has not been filed yet, since it is unrealistic to expect that to happen without the petitioner actually commencing its business. Paragraph.
Order may be communicated.
Yeah, the petition is disposed of in the above terms. A copy of this order be forthwith communicated to the Secretary, Excise Department, Government of Orissa.
May I just humbly pray for 2 things? Instead of 31st, can it be 20th minutes? Because the Lordship will appreciate
28.
20th, 20.
28.
28 may not be too short. Not otherwise, this 1,10,000 again goes down the drain. So next year comes, I have to file another application, and the entire process is again repeated.
20th will be too short.
Next week. You can say 27th.
27.
All right. 27.
One small observation, Lord, that as per law, Lord, all observations beyond 15 days should have been rejected.
That several decisions your Lord.
No, already there.
No, because
That itself is there.
Not in spite of that, my Lord, Lordship appreciate the commissioner receives objections. He holds a video conferencing.
You can, I say, in view of the decision of this court in Gitanjali Sahu, the question of entertaining any further objections simply does not arise.
After the due date of 15 days.
Right.
Item number 2.
Greatly obliged.
May I please? Impun order is at page 15, madam. Direction for promotion during pendency of the vigilance case.
Same.
And next date is 27th March.
All right. Same order. Listed 27th March, the impugned order of the legislature shall remain state till then.
Item number 3.
None appears dismissed.
Item number 4.
So item number 4, on behalf of Mr. Niraj Kumar Sahu, pray for 1 week after, though he is suffering from fever, and also will file reply to the affidavit filed by the respondent.
There's no need for all that, sir. This is a writ appeal.
Yes,
Constable, the appellant stated to be unwell. List on. Eleventh, 16th May. 16th May.
that's the interim order from.
Interim order.
Item number 3. Both the matters. Supplemental list fresh admission item number 1. ARBP 1 of 2023.
I pray for 2 weeks time to file the counter affidavit, Miller, because the officer in charge suffered an accident. That's why I could not file in time, Miller.
Last opportunity, opposite parties to file a reply within 4 weeks, rejoined of the next day.
Obliged.
12th May.
Obliged.
Item number 2. Lordship,
Yes, please.
I'm audible. Your
Yes.
Lordship.
Yes, please.
application under section 11, surplus 6, that the petitioner filed for the appointment of arbitrator panel. That
Yes.
the,
Yes,
as
yes.
per- As per the acceptance of tender,
Yes,
clause number 11,
page
page 41, your lordships,
one
there is
minute.
an arbitration clause,
1 minute, sir.
public lordship.
Arbitration clause. Yes.
Arbitration 11, surplus to arbitration clause.
Okay, all right, all right. And where is your notice?
Notice, your lordships, annexure 7, your lordships, page number 79.
All right, all right. You say notice returnable. 12th May, sir.
Your public lords.
All right, all right.
Item number 3.
My lordship, item number 3, the matter is still pending before the Honorable
Yeah,
Supreme
no,
Court
they've,
regarding
It is still sub judice before
the Honorable Supreme Court matter.
I see. So matter is still pending in the Supreme Court. It's stated to be still pending in the Supreme Court. List on 14 July.
Obliged.
Item number 4.
I have not paid the court fees.
So when do you propose to pay?
Milord, 15 days.
Why? 494 rupees you can pay today, sir. 500 rupees you can't pay today.
I will pay Monday.
Counts the petitioner states that the deficit court fee will be deposited in the next 2 days. At his request, list on next Friday, 17th March, correct.
Item number 5.
Item number 5, we have just received the last order and there is a stay also of that judgment. Extension order is also.
All right.
That award out of which this appointment happens, that's stayed now.
All right. It is seen that the learned single judge has on 8/2/2023 stayed in arbitration appeal number 57 of 2018, stayed the operation of the judgment dated 11 September 2018 passed by the district judge Khurda in arbitration petition number 110 of 2023. So we simply adjourn this, or?
That's adjourned.
All right. In that case, the matter, the present petition is adjourned sine die, awaiting the decision in arbitration appeal number 57 of 2018. Liberty to the parties to mention the petition for listing thereafter.
Specialist press admission item number 1, CRLMC 272 of 2018.
To withdraw, Milord.
Dismissed as withdrawn.
1 and 43, Milord.
1 and 43. All right.
Item number 2.
None appears dismissed.
Item number 3.
No instruction, my lord.
No instructions.
Obliged.
Item number 4.
Lordship, item number 4, liberty be granted to resolve the points at the time of
All
charge.
right. Permitting the petitioner to raise all these the appropriate steps.
Obliged, Lordship.
All right.
Item number 5.
Memos taken on record. No instructions dismissed. No, not pressed. Dismissed is not pressed.
Item number 7.
None appears dismissed.
Item number 8.
None appears dismissed.
Item number 9.
No instructions dismissed.
Item number 10.
None appears dismissed.
Specialist item 11.
None appears dismissed.
Item number 12.
No instructions with liberty, Milord.
If it's no instructions, why liberty, sir?
In case he wants to revise.
Then he will come anyway. No instructions dismissed.
Item number 13.
None appears dismissed.
Item 14.
Please, Milord. Lordship, may I kindly have the IA number 44 of 2020, Your Lordship. It was filed for conversion to a revision application, Your Lordship. That may be allowed, Your Lordship.
All right, that IA is allowed. Then
That's all, Your Lordship. I'll file a fresh cost title and consolidated cost title.
all right, consolidated cost title be filed within a week. This before the roster bench.
And renumbered as a criminal revision. Your
That will also.
Yeah.
This before the roster bench on 3rd May.
Grateful, my lords.
Item number 15.
None appears dismissed.
Item number 16. My lord, the petitioner raised all the points at the time of a framing charge, my lord.
All right. Permitting the petitioner to raise all these.
Item 17.
None appears dismissed.
Item number 18.
No instruction.
No instructions dismissed.
Item number 19.
None appears dismissed.
Item number 20.
Same.
Item 21.
Memo taken on record. Dismisses withdrawn.
Item 22.
Here the petitioner challenges the cognizance order on the two grounds, Lordship. The check has been issued in the bank of Lordship UBI Bank of Rasgobindpur branch, which comes under the court of SDGM Baripada. But the JMFC Joleswar has taken the cognizance, and there is also an defective that there is insufficient of court fees.
All that you can point out there, sir.
There is a judgment also of the Honorable Supreme Court, Lordship.
You can point out all that, sir. You can seek discharge. Permitting the petitioner to raise all pleas at the appropriate station in the trial court, the petition is disposed. All right. Sir.
Item 23.
The interim order is vacated. Memo taken on record, dismissed as withdrawn.
May I make a mention? Item 17 is fresh notice has to go. I was just in other court. I was
Item 17.
17.
Fresh
notice is to go. I was in other court.
What is the matter about?
The matter is regarding 125 maintenance.
No. You raise all please.
That's mine. It has been mine. Non-appeared has been.
No, okay. Put his appearance. You say permitting the petitioner to raise all pleas at the appropriate stage.
Yes,
not interfering. Yes.
Fresh notice because the OP has not appeared. Notice is not sufficient.
That's all right, sir. How much is the maintenance ordered?
4,000.
Nothing, sir. These days and age, nothing. 4,000 is nothing. Nobody can survive on 4,000. Considering that the interim maintenance amount is just rupees 4,000 per month, and accounting for the cost of living and CPI index, the court does not consider it appropriate to interfere with the impugned order. The petition is dismissed. All right.
Item number 24.
None appears dismissed.
Specialist item 25.
None appears dismissed.
Item number 26. 26 and 27.
Item 25, my lord.
Yes, yes. The memos are taken on record. Dismiss is not pressed. Right.
26 and 27. Item 28.
Permitted to withdraw, my lord.
Dismiss is good. All right.
Permitted to withdraw.
Right.
Permitted.
Item number 29.
None appears dismissed.
Item number 30.
None appears dismissed.
Item 31.
Please, Your Lordship. Here I have challenged the cognizance under section 420, 406 and 34. This arises out of a case of a civil dispute. Mere breach of contract, as in such cases, criminal proceedings cannot proceed, because if Your Lordship may see annexure 3 series, they have also instituted a civil suit against the petitioner. But if Your Lordship may go through the complaint also, it
Also
is
not served, sir. No such address. It's come back unserved.
Yes, my lord, the address that was given in the complaint, my lord, and there is another permanent address, if Your Lordship may kindly.
Not really, sir. Permitting the petitioner to urge all the pleas at the appropriate stage in the trial court. The petition is disposed of. All right.
32.
Grateful.
None appeals dismissed. Interim order.
Item number 33,
Same. None appeals dismissed.
item number 34,
None appeals dismissed.
item 35,
None appeals dismissed.
item number 36,
None appeals dismissed.
37,
Unfortunately, it is against three metallics. And here I have come for miscarriage of justice. Lordship will see the complaint petition without the approval of the commissioner. The complaint has been filed. And I'll take your lordships to
EPF
page
Act.
11.
This is EPF Act.
EPF Act, Employees Provident Fund Act, under section 14A, para 7, page 11, Lordship will kindly see under that the Regional Provident Fund Commissioner being satisfied regarding failure of submission of returns has sanctioned prosecution against accused persons under section 14A of the Act by the order number so and so, fill up the gaps. So the court will fill up the gaps. That is the.
What happened to the service of notice?
I have served my. It has gone by registered post.
Well,
I have also got the receipt. Postal requisites are there, my lords.
No, the more noting is
No, it is
late
there.
filing of requisites. Late filing.
Late filing, yes, late filing. But notice has gone.
No. Can't
Yes.
go. Through the court it has to go. So that is not gone because file late.
Oh,
All right. Requisites could not be, the notice could not issue because requisites were filed late. In the interest of justice, fresh notice be issued, returnable before the roster bench. On 28th June, interim order to continue.
all are same.
Right.
Your lordship is so fast. It's just like Justice Tuljapurkar, my lord. So when I was in Supreme Court, people were, the lawyers were afraid. Well, immediately he will take up.
Justice Chinnapreddy would finish by 11:30.
Yes.
item 41,
Tuljapurkar went from as a district to Supreme Court.
Okay.
And the day he retired, the next day he vacated the quarter.
Brilliant mind. Brilliant.
Brilliant.
All right.
Much obliged.
item number 41,
But I may be permitted on behalf of Mr. Dhal. Lords, here I have challenged the order at annexure, Lords, may see 3, Lords.
2011 matter. What is this?
Lords, annexure 4, wherein I have alleged that the opposite party number 2, while on taking bail after submission of charge sheet, he was not present in court and was impersonated by another person, my lords, which was under challenge at annexure 4, my lords.
So all this can be inquired into, sir.
Lords, the learned court below did not feel deemed fit to inquire into the matter, and if a lordship may go through the order, he has just dwelled the matter in the case that since the learned APP did not oppose the petition, there is no merits.
What is the offense?
Lords, the offences are under sections, my lords,
420.
341, 323, 342, 294, 50.
All this can be urged at the time. You say permitting the petitioner to urge all the pleas at the appropriate stage in the trial court.
It was urged in the trial court. That is why I have come up with it.
Sorry?
It was urged. Here, the petitioner is the complainant in the court below.
So the court refused to take cognizance, is it?
My lords, he refused to take cognizance of the fact that the impersonation and the fraud that was played by the opposite party number 2 did not bear it into the mind.
Show me the impugned order.
My lords, it is at annexure 4, starts from relevant page number 11. My lords may see relevant page number 16. First para. On the other hand, the learned APP has not objected to the appearance of the said accused, Rajendra Samantai, which is OP number 2. And as an important member of the prosecution, the learned APP is supposed to be well versed with the facts of the case instituted by the state and about the accused persons. In this context, this court arrived at a conclusion that there being some impersonation, the learned APP must have objected to the same.
Yes, complaint after lapse of 7 years. Sir. That is a good enough ground. A perusal of the impugned order dated 21st October 2011, passed by the learned Judicial Magistrate First Class Patamundai.
No, because it was into my knowledge when it came to my knowledge, then only I filed a petition.
In GR
And also sent a letter.
85/2 is that the plea that the petitioner accused was impersonated was taken almost 7 years after the cognizance had been taken of the offense. To stop the application itself, which was dismissed by the GMFC, was filed at a stage of defense evidence. So as noted in the impugned order, the plea was taken 7 years after lapse of 7 years. Stop. Having heard learned counsel for the petitioner and having perused the impugned orders, the court is not persuaded that the GMC has committed any grave legal error in declining to take cognizance of the offences. Accordingly, there is no merit in the present petition and it's dismissed as such. Right.
Item number 42.
None appears dismissed.
Item number 43.
The second matter also. None appears dismissed.
Item number 44.
After completion of evidence on the side of the OP number 1, the petitioner filed annexure 2.
Your OP number 1.
Mother OP number 1.
Who is for the petitioner?
I am for the petitioner.
You just now said OP number 1?
After completion of evidence on the side of the OP number 1, I filed an annexure 2, page 13. With effect to issue a notice at the cost of the petitioner. Page 13, annexure 2. I have given the name.
For summoning the people.
Yes. The Lord Court below has rejected my petition by the annexure 4, running page 23, second para. Only on the ground that I am dealing the matter. Page 23, second para. Last I am of the contrary opinion that the petition is filed by the OP only to delay the present proceeding.
Yeah. This is 125 proceedings.
125 proceedings.
Why should we interfere?
Well, I filed the petition to, after examination of the OP number 1, I filed the petition to for evidence on my side.
That's all.
That was denied by the court.
Correct.
I am for the OP number 1, my lord. As per instruction from my client, the case has been disposed of. CRP 237 of 10. Pending before the judge, learned judge, family
Counsel
court.
for the respondent states that the main case before the family court has itself been disposed of. In that view, the matter, the present petition is rendered infructuous. It's disposed of.
Item 45.
None appears dismissed.
46.
My lord, on behalf of SK Singh, no instruction, my lord.
No instructions.
Item 47.
None appears dismissed.
And 47. I'm not feeling well, my lord. This matter.
What is there in the matter, sir?
Due to throat infection, I'm unable to.
No, it's a 2000. It's a fairly old matter, sir. 2018. permitting the petitioner to raise all pleas in the appropriate stage in the trial court. The petition is disposed of.
1 week after my lord. 1 week after my lord.
No,
48.
the interim order is submitted.
48, my lord, the petitioner is wife opposite party number 1. She has filed petition into 2009 for issuance SDGM culture of the monthly maintenance 2,600 of form 50,000, 15,000 per month. And my lord, kindly come to annexer to the SDGM as for finance para 12, page 19.
Yes.
So far as the income has the ability of the OP to pay the insurance rate of maintenance as paid for his.
What is this amount, madam? 2,600.
2,000.
5,000 per month.
5,000 per month.
It's all right. These are not substantial sums at all. By the impugn order, the learned SDGM culture has, while disposing of.
He is appearing for the opposite party.
I see. Who's for the petitioner? Why not? Why should you start? Who's for the petitioner? All right. None appears to the petitioner. Dismissed for non-prosecution. All right.
Item 49.
I will raise all the points.
Permitting the petitioner to raise all these at the appropriate stage.
Item number 50.
Dismiss instructions.
Item 51.
My lord, item 51 and 52 pass over.
All right.
Item number 53.
Memo taken on record. Dismiss is not pressed.
54.
54, my lord, prayer for quashing of FIR. And the matter is now pending before the consultation authority. During pendency of the consultation authority matter, the informant has filed the FIR that by manipulating the documents.
So 468, 471.
Common purchase vendor, my lord.
No. So 468, 471.
419, 467, 471. That is the offense, my lord.
Take all the pleas at the appropriate stage, permitting the petition to raise all pleas at the appropriate stage. All right. Interim order.
Item 55. 55, 56, 57, and 58.
Memos taken on record. Disposed of is not withdrawn.
Item number 59.
May be permitted to
raise all
submit on behalf of Mr. Alok Kumar Kaur, my lord.
Oh.
My lord, the challenge is against the cognizance order taken by the learned JMFC under NI Act, my lord, 138 section, my lord.
Right.
My point is only two faults, my lord. One is
jurisdiction.
No, my lord. No jurisdiction, my lord. First is a violation of 138B, my lord. The drawer of the check, the written notice has not been served on the drawer of the check, my lord.
Oh, who's the drawer of the check?
Drawer of the check, my lord, petitioner number 1, my lord. Petitioner number 1 is the drawer of the check, my lord. He has not been served with the demand notice. Notice was served on OP number, petitioner number 2, who is not the signatory to the check, my lord.
I'm appearing for the opposite party number. I'm appearing for the opposite party in this case, Your Lordship. During pendency of the criminal application CLMC, we have filed an application for recognition of party as an opposite party before the learned court below. But that is not been taken on record, Your Lordship. That is pending.
Where is it pending here?
No, Your Lordship, trial court, Your Lordship.
Trial court, See, we permit you to raise all pleas.
Second, the cognizance is taken. The company has issued the check under section 141 of the.
So only directors have been proceeded the case.
Only company
SMS Pharmaceuticals.
A company itself has not been party.
So SMS Pharmaceuticals.
Miller, in view of that, Miller, there are
So the drawer of the check is the company. You are for the complainant, Mr. Siddhant.
Yes, sir.
You are for the complainant.
Yes, your lordship.
So the check was drawn by the company.
Yes, sir. No, your lordship. Which was drawn by the which?
No. Let's see the check. You have a copy of the check.
No, your lordship. No, I'm not having the copy of the check right now with me, your lordship.
Where is it? You have the check copy.
Miller, I draw your lordship's kind attention to page 11. Page 11 of the complaint petition, Miller. Miller, para 7, Miller. Of the complaint petition before the lower court, Miller. That filing no other alternative way, the complainant served legal notice to the accused number 2 through his lawyer by narrating the incident there. And first of all, Miller, he has in para 1 stated that.
No, who drew the check, sir? Where is the pleading as to who drew the check?
Miller itself has stated that the company chairman cum managing director, city cum engineers issued the check.
Yes, sir, lordship.
Company has issued the check. The director was petitioner number 1. But the complainant served notice on petitioner number 2.
Where is the copy of the check, sir? You're not showing that. From the copy of the check, we'll know who drew the check. Is it the company's stamp or individual?
Yes, sir, lordship. The company has a stamp on the check, your lordship.
Then you have to make the company a party, sir. The Anita Hada case is there.
Yes, Miller.
Godfather Travels.
I filed an application before the learned court below. That is pending, your lordship. To implement the company as a party to the said.
Is there a provision to do that? I don't think so. You can't amend the complaint. There's no provision to amend the criminal complaint. It's not like CPC. There's no provision in law for that.
Yes, admitted in the grounds in para 3, ground C.
No. See, the law is settled. You file a fresh complaint making the company a party, it's different. But here, that must be time barred now because the notice also would not have gone to the company. Did the notice go to the company?
No, Miller. No notice is issued to company.
So unless it's preceded by notice, you simply can't amend the complaint.
Yes.
That's not the law, sir. You see,
Lordship may keep it to next week. I'll verify the records in the learned trial court.
One of the pleas raised by the petitioners, counsel of the petitioners, is that the company that issued the check has itself not been made an accused. And therefore, notice could not have gone only to its directors. Reliance is based on the judgment of the Supreme Court of India in Anita Hada versus Godfather Travels and Tours. That citation. Paragraph, counsel for the complainant seeks some time to examine the matter. Interim order to continue. List before the roster bench. On 4th May.
Oblige, your lordship.
All these 4 matters are same, Miller.
All right.
Item number 60.
No, all the cases, Miller, interim order to continue.
Yeah.
Obliged, Miller.
Item 60.
None of this.
61.
Lordship, here is a matter wherein the application filed by the petitioner for sending the disputed document to the handwriting expert has been rejected, Your Lordship. So now law is well settled and clear that adducing evidence in support of defense is a valuable right, and the accused cannot be convicted with the right to rebut the evidence being denied, Your Lordship. Lordship may see the relevant portion of the order at page 24, Your Lordship. Page 24 of my petition. Lordship has it?
Yes.
5 lines from the bottom of the first paragraph, Your Lordship. Law is well settled that value of expert evidence under section 45 of Indian Evidence Act is not conclusive evidence. This is the finding of the lower court. In the case law reported in AIR 1973 SC 1346 SC 316, the citation is not clear, Your Lordship. It is held that court is not to give much weight to the evidence of the handwriting expert, and his evidence must yield to the positive evidence in the court, Your Lordship. Similarly, in AS so and so, it has been held by the Honorable Apex Court that the evidence of handwriting expert is no substantive evidence, requires corroboration, Your Lordship. In the present case, what has happened is there was a junior engineer who had prepared an estimate for the construction of a road, Your Lordship. Now, while being cross-examined, he is denied that the particular handwriting does not belong to him. After that, he is also mentioned in his cross-examination that he has no problem if the same is sent to the handwriting expert for verification. After that, the petitioner herein, they filed an application for sending the application to the disputed document to the handwriting expert, Your Lordship. It has been rejected by way of the present impugned order, Your Lordship. That is all, Your Lordship. I am relying on two judgments of the Honorable Supreme Court, Your Lordship, in this.
Where is an interim order passed?
Your Lordship, in this matter, there was an interim order, Your Lordship. Last it was take up on 18/6/2019.
No, where is the first interim order passed?
First interim order, Your Lordship.
There is no interim order, sir.
27th of February 2019.
See that order? Where is the interim order? Show us.
It has been continued a lot. 27th of February 2000.
No, what is continued? There must be first of all an interim order, only then it can continue.
Right.
Ah. I don't think it was stayed at any time.
Lordship, the order dated 27th February 2019 states interim order to
How will it continue? Unless there is an interim order, it can't continue, correct?
Before that, I don't see an interim order.
So how can simply non-existent interim order cannot continue?
But as per my instructions, the lower court proceedings are pending, Lordship. This is of the year 2018.
Now let it start, sir. Who's for the other side?
Miller.
What do you say?
The case of the prosecution is that without executing the work, the money has been misappropriated.
So you want some comparison of handwriting, sir?
He wants the comparison at not at the stage of prosecution. He has to take the benefit at 243 of the CRPC.
It is not their case that have delayed the matter or have used any dilated tactics to delay the matter. As the cross-examination got over, the next week I filed the application for the disputed document.
Maybe. The prosecution at the stage of prosecution, the accused has no right to adduce evidence from his defense and to collect evidence from his defense.
All right. The objection taken by the opposite party, state, you are for the state, vigilance department. For the opposite party, vigilance department is that the petitioner accused cannot insist on summoning of an expert for purposes of evidence at the stage of prosecution evidence. So he will have a right to do so when he enters upon the defense. And the defense evidence is to be led. Paragraph. That if the matter will not interfere in the imputed order of the trial court, the court clarifies that it will be open to the petitioner at the appropriate stage to renew his prayer for summoning of an expert. The petition is disposed of, interim order is vacated.
Item 62.
Item number 62, kindly pass over, Your Lordship.
All right.
63.
My Lord, liberty may be granted to raise the points.
Raise all, please.
Item 64.
Opposite party number 2, my Lord.
My instruction
is dismissed.
The matter has already become infructuous, my Lord.
Yes.
65.
My Lordship, challenge the order of the cognizance and abide annexure 3, Your Lordships, annexure 3, and all the accused are arrested and released on bail, and thereafter, Your Lordships.
What annexure?
The informant and other persons also, with the co-op, the village people and the informant altogether assembly, and they before the Durga Puja. Durga
That's it.
Puja,
There's no
other-
compromise, nothing, sir.
Compromise, your lordship, that was also compromise.
Where is it? Where is the compromise?
Compromise, I affidavit also file here, so information.
Where?
Information file affidavit here. There is a amicable settlement bill.
3 affidavits have been filed by the complainants in this court stating that the mutual disputes have been settled and that they do not wish to pursue the complaints against the present petitioners. All right. In that view of the matter, the take from the prayer clause and all proceedings consequent that are hereby quashed.
Oblige.
All right.
Item number 66.
Nana, please.
Item 67.
May I please, your lordship? Here the petitioner, who the lady was engaged as a SS Sikha Sahaya and challenging the order of cognizance under Annexure 6, my lord. And the relevant page is at page 20 of my petition, Annexure 6, my lord, by which the learned magistrate took cognizance. Your lordship, kindly see page 23.
What are the offences?
420, 468, 471. Now, only 1 minute I will take the lordship. It is alleged there I was being selected by producing some forged documents. Admittedly, I had passed matriculation certificate examination and +2 examination. I have also produced, your lordship kindly see, I have also annexed Annexure 2 and Annexure 3, my certificate which are genuine, my lord.
Who is going to look at this stage? Nobody can look into that.
And my only submission is there. Can the sub-collector give a statement or opine that my documents are forged unless the authority who had issued the certificate, such as
Maybe
authority,
that's up to them how they want to prosecute.
no, mine. You also kindly see. I also implemented as a board of secondary education and the council of higher secondary as a party.
Not at this stage.
So during my only submission before lordship there, during investigation, none of the witness was examined from by the IO or examined the authority or any employee of the board of secondary education or council. So I hope that they are the best witness to say the certificate which I have produced is a forged one. Your lordship kindly appreciate.
That will happen at the trial, sir.
No, your lordship kindly for a moment, your lordship. Answer 2 and 3, your lordship kindly see for a moment.
Yes.
That is my board examination certificate.
Yes.
And answer 3 is my class +2 certificate.
Right.
And now your lordship kindly see answer 4.
Yes.
That is the list of the charge sheeted witness. And from the charge sheeted witness, your lordship will find that none of the authority or any employee of the board or council was examined. So my only submission before lordship is there, and only prayer before lordship is there. They are the only competent person who can say that my documents are forged. No other person can say. And besides, my lord, your lordship kindly see the charge sheet as page 19, Annexure 5.
Yes.
Your lordship will find the para 2. During investigation, the complainant and other witnesses have been examined and their statement have been recorded. The spot has been visited. The third document, that is mark sheet, other certificate in respect of Sikha Sahayaka, alleged and accused person during investigation, except accused such and such, hence an MW may be issued. And lastly, lordship kindly see, during investigation so far, primary evidence have been well established to prosecute the accused persons, namely such and such. So no such, the IO also did not suggest that what offense I had committed in the charge sheet. Your lordship says that charge sheet also silent. Charge sheet doesn't suggest that what are the offense I had committed. And the learned magistrate also taking care in the Annexure 5 charge sheet to cognizance mechanically. And there is no such allegation directly that I such and such produce such and such certificate which is forged. So I mean, lady, my lord, only because it was developed because some persons
file their resignation, apprehending that
They'll get caught.
they will be caught. And so by that time, I got selected in another post and I also resigned from the post. So random, so they also included me. But that is why for precaution measurement, I implemented Secretary Board of Secondary Education, Secretary Council as a party. They have also appeared, my lord. They have also appeared, my lord.
It's all right. Permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petitioner is disposed of. The interim orders vacated.
Original copy.
Item 68. May I please, my lord? My lord, in item 68 and 69, liberty
Yes.
may be given to raise my contents before trial court, my lord.
All right. Permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petitioner is disposed of. Right. Right.
Item number 70,
None appears dismissed.
71,
None appears dismissed.
72,
None appears dismissed.
item number 73,
None appears dismissed.
74,
Madam, 74, I am concerned. This is challenge to the FIR itself. So the scope is very limited. I am only praying, Madam, I may be allowed to make challenge if contingency arises post facto the charge sheet.
Correct.
Because if there is a charge sheet comes, then I will challenge.
Correct. Permitting the petitioner to raise all pleas urged in the present petition at the appropriate stage. The petition is disposed of. The interim order is vacated.
item number 75,
Item 75 in meantime matter has been settled, my lord.
All right.
Offense number 294 332 506 IPC, my lord. Hello, 2 weeks time, my lord. Opposite party perhaps issue notice to opposite party, but till today has not appeared. 2 weeks time, my lord, maybe given, my lord.
Counsel, the petitioners need some time to place and record. Copy of the settlement.
Settlement.
Copy of the settlement arrived at between the parties. List before the roster bench. On 2nd May, interim order to continue.
My lord.
item number 76,
None appears dismissed.
item number 77,
76, Madam.
76.
May I please, Lord Sir? The petitioner challenged the order passed by the London court below by rejecting my application for exemption the handwriting to the handwriting expert at the cost of the present petitioner, my lord. So far as the facts is concerned, in a case, the amount has been overwritten, which was categorically admitted by the PW3, who is the branch manager of the bank. He has categorically admitted the amount has been overwritten and short signature is there, which is also unknown. In fact, that signature is doesn't belong to the petitioner.
At the appropriate stage, urge all this, sir. At this stage, we can't possibly decide this issue. Permitting the petitioner to urge all pleas at the appropriate stage in the trial court, the petitioner is disposed of. The interim order is vacated.
77,
Please, your lordship. My lord, on behalf of Mr. Lalitandra Mishra, may I allow to press this matter? My lord, the petitioners challenge the initiation of proceedings. My lord, this may be quashed because at the same time, 2 criminal proceedings is continuing. My lord.
What's the offence, sir?
The offence is under Annexure 1, my lord. Kindly have a glance. Offence is 379, 34, 120B. My lord, at the same time, 2 case has been proceedings has been continuing, and subsequently another proceedings and FIR has been lodged. Same set of transaction, same offence, and same dates and same place. So my humble submission is that this is a case of double jeopardy.
No, we don't know that.
My lord, on the last court. On the last occasion, your lordship has directed the opposite counsel the same order dated, my lord.
It's a case of elephant poaching, my lords.
The elephant poaching, my lord.
There's Arms Act and, my lords, Section 51 of the Wildlife Protection Act also. So 2 CC proceeding was.
Anyway, permitting the petitioner to urge all pleas at the appropriate stage in the trial court. The petition is disposed
My lord,
of.
there is an interim order.
Interim order is vacated.
My lord, interim orders
Seven.
continue. My lord.
No, no. First, yes.
78.
On the last occasion, CMC number 22230, same case, my lord. Your lordship has granted interim order and government council to take instruction.
No, sir.
Within 4 weeks.
All right.
Item number 78.
At 78, my lord, all the points that I am preparing with chair.
Permitting the petitioner to resolve these.
Item 79.
Item 79 on behalf of Mr. Siddheshwar, ma'am, will be taken up next week on any day next week.
Or what is
It's
the
on
matter about?
accommodation, my lord.
What's the matter about, sir?
It's matter on the NI Act. ma'am.
Ah,
Here is some legal point. There's already filed accommodation memo today. Anytime next week, my lord, any day.
205, sir. What's the actual issue? What's the actual issue? Cognizance, 1cc. What's the, this is a 138 matter.
My lord.
Ah, it's all right, sir. You raise all pleas, permitting the petitioner to raise all pleas at the appropriate
My lord,
stage.
interim order is there, my lord. That is the stay of NBW is also.
Yeah, you see, it is seen that on 20th November 2018, the NBW issued against the petitioner was stayed. The petition will appear before the trial court on 27th March 2023. Till then, the said interim order will continue. On that day, it will be open to the petitioner to seek appropriate orders from the trial court. The petition is disposed of.
6 matter, my lord. 79 to 82 and 89, 90.
90.
All right, 6 matters, all same order.
Item number 83.
None appears dismissed.
Item number 84.
Item 84, my lord, I have no instructions.
No instructions.
Item number 85.
None appears dismissed.
86.
My lord, herein, I am challenging the order of cognizance, my lord, which is at Annexure 4, my lord, wherein the learned court of SDGM Sambalpur, where it is ordered dated 8/3/2018 to cognizance of the offence under section 306 of the IPC against the present petitioner. My lord, the present petitioner, there is no iota of evidence in the entire case, my lord, against the present petitioner, save and except for the fact that he had called the deceased the day before. And except for that, there is not a single piece of evidence nor any statement from any witnesses regarding the
The
incident.
point is that at what stage has been stayed, the whole trial court has been, thing has
My
been
lord,
stayed.
My lord, there is an interesting thing, my lord. I have annexed the
Charges have
charge.
been framed or not? That charge is framed? Not yet.
My lord, the proceeding was stayed, my lord.
I know. So if charges are not framed, you can urge all this at the stage of charge.
My lord,
Ah.
my lord, may permit me, my lord, for just a minute. My lord, I have annexed the charge sheet, my lord. My lord, in the FIR, the scenario is, my lord, the deceased was a widowed lady, and she was being pressurized by her in-laws and being tortured by her in-laws for grabbing of property of her husband, my lord, of her late husband. And this has been specifically mentioned in the FIR. But the charge sheet, my lord, they have somehow managed, and the entire allegation against the father-in-law, the mother-in-law, and all the in-laws have been exonerated, and only on the basis of the CDR, the present petitioner has been implicated.
Mobile call,
Mobile call.
just before the death.
Not just before the death, my lord,
Previous day.
the day before.
Ah.
That is the only piece of evidence, my lord. And
So you can apply for discharge.
my lord,
You can apply for discharge.
My
Permitting
lord-
the petitioner to raise all pleas at the appropriate stage.
my lord may give me one more opportunity to apprise, my lord. This is a very good case, my lord. And my
No,
lord,
no, the thing is,
indulgence is required
stage.
for
The stage at which one appreciates. See, if the trial court is helpless, that stage has been crossed, one thing is there. Trial court, we can easily point this out and seek discharge in the trial court itself.
my lord, the case is pending in Sambalpur, my lord, and my lord, the petitioner really doesn't have any role to play in the entire.
All right, what has to do with Sambalpur?
My lord, may give me one more opportunity next week. May call this matter next week. I'll apprise my lord.
That's
And
not- You've enjoyed a stay for how many years now? 5 years?
I
5 years.
request
4
my
years.
lord-
4 years.
I
4
request
years.
my lordship indulgence for just
4 years, no, 4 years of stay is a lot. You've just delayed the trial. Now nothing will be remaining there.
my lord, I would
You
not
say
have-
permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petition is disposed of. The trial interim order is vacated. A copy of this order be sent to the consent. All right.
Item 87.
Annex 6, the order of cognizance is order under challenge, my lord. And all the petitioners are the government officers. While doing the one government project, my lords, and they have evacuated some family for settlement of the 75 families and 70 families, and in the resolution by Annex 3, and the petitioner has signed, and the notice has been issued to the opposite party, but in spite of that, he has not appeared to this honorable court, my lords. And there are 4 grounds. Section 197 1B sanction has my lord. And another is and he has agreed by the Annex 3 to vacate the and for the settlement. And the expectation of 10 lakhs is paying for compensation, and settlement will be made by the forest department, my lords. And the expectation of more money, and that regarding lodging affair, but he has not lodged the affair. And the incident is 12/6/2018, and the complaint has been lodged on 16/7/2018, my lords. And this honorable court's one judgment is there, my lords. In the similar case, the order of cognizance has been passed, my lords. And it is a development project of the government, my lord. And all the petitioners are the government officers.
Are they still serving?
Yes, my lord.
No.
No. One is first.
All must have retired now, sir.
Now, the petitioner number is serving, and 2 and 3 is retired, my lord. 5 years. 2 and 3 retired, and 4 is also serving, my lords.
Lady guard.
My lord. And all the under section 202, which has been recorded by the London Magistrate, my lords, that is a complete, and no, he has signed the resolution. He has agreed to vacate the place, and it is a government project, my lord. And in spite of that, he has filed complaint, and the cognizance has been taken. And sir, Annex 3, well, at page 27, the opposite party has signed. That is Govardhan Lai. Opposite party, in spite of notice of this honorable court, he has not appeared also.
No sanction given for prosecution.
No.
Find out, sir, what is the government doing?
Yes. Let me take instructions.
All right. Counsel for the state each time for instructions on whether sanction for prosecution of the petitioners was at all granted. Has at all been granted? At his request list on, let's move for the roster bench. On 18th April, interim order to continue.
Item number 88.
None appears dismissed.
8990 taken. Specialist pastor matter item 51.
May I please, my lord? My lord, one of the principles on the basis of which your lordship in exercise of the 482 jurisdiction can quash the proceedings is, suppose on reading of the FIR of the complaint, my lord, on their face value and accepting it on its entirety, the offense is not made out, my lord. Now, this is a clear case, my lord, where the offense of section 406, 420 and 506 read with section 34 on which cognizance has been taken by the learned court below are not made out, my lord. My lord, now for an offense under section 406, there are 2 things are essential. One is that there should be inducement for enforcement of property and dishonest disposal. And for an offense of under section 420, there is a catena of judgments, my lord, your lordships have held that merely breach of trust would not make out an offense under section 420. And to make out an offense of section 420, the intention to cheat should be there from the very inception, and it can be presumed that it has developed later on, my lord. My lord, I'll just read out the.
Have you served the complainant here?
My lord, notice was served, my lord. Somebody
was it served on them?
Yes, my lord.
1 minute.
Your lordship may just kindly have a look at the complaint petition. Just 4 paragraphs. My lord, he was entrusted with the work by the petitioner.
No. I think the last noting is AD, not returned.
When notice has been served, my lord.
No, the notice is AD of notice issued to
Yes,
opposite
ma'am.
party
Yes,
number
ma'am.
2 by registered post has not yet been returned.
My lord,
You say fresh notice be issued to opposite party number 2 returnable. 3rd May before the roster bench, interim order to continue.
grateful, my lord. 52. Now this second case, my lord, arises out of offense committed under Child Labor Prohibition and Regulation Act, my lord. My lord, your lordship would kindly see that an inspection under Annexure 1 was carried out by the labor officer, wherein she has categorically held that none of the everything stands complied. There is no employment of child labor and all. The only, your lordship may kindly see Annexure 1 at page 13. The only thing what is pointed out at serial number 3, whether notice containing abstract of section 3 and section 14 is displayed under section 12. My lord, thereafter, at the bottom, my lord, notice is served on me. My lord, Annexure 4, I give my reply, my lord. Annexure 4 at page 17. Annexure 4, I reply that with reference to the inspection report under Child Labor Prohibition Regulation Act, we would like to inform you that we have not employed any child labor in our establishment, and we are all well aware about the Child Labor and So Act, my lord. The notice containing abstract of section 3 and section 4 has been displayed.
No, what was the not displaying something?
My lord, your lordship would see kindly the internal page 5, my lord, the relevant section.
Abstract of sections 3 and 14
3 and
not
14, my lord.
displayed. That's all.
That's all, my lord. But for that, my lord, I have to face a criminal prosecution. I'm a reputed businessman of this.
Offense.
Sorry?
That is an independent offense. One is, my lords, the establishment says that I have not employed any child labor. And the other, my lords, under the act, there is an obligation on the employer to display.
Yeah, but here there is no allegation apart from not displaying, which is the other offense.
No, my lord, there is no.
The only offense is that he did not display.
Yes, my lords.
But I'm a reputed businessman since so many years.
Yes.
But for a small trivial, your lordship, and in fact, my lord, recently the Honorable Apex Court has said, my lord, I don't have a copy, my lord, I can give it this. Lordship would kindly see, and over there I've given my reply, my lord, but the complaint is silent about my reply. And in the counter, they admit that your lordship may kindly see.
But have you in fact displayed?
No. Now we have displayed, my lord, we have complied. That thing was pointed out, we complied with it. And now in the counter, your lordship would see.
Para 7.
Paragraph 9 at page 4, my lord, the last paragraph. The averment of the petitioner regarding receipt of compliance in the office of the district labor officer, Khurda, Bhubaneswar, it is submitted that no such compliance report is available. My lord, their seal and stamp is there, my lord. The seal and signature is there. Annexure 4, my lord, your lordship would see. Annexure 4 at the bottom. Well, they receive it. And thereafter they go and this file is complaint case. And thereafter they go, assuming without considering that such report at Annexure 4 is duly received in the office, the same cannot be accepted as compliance as the petitioner had neither enclosed a copy of the notice containing the abstract of section 3 and 14 of the said act, nor any photograph displaying the notice within the premises of his establishment along with the compliance report. Mere submission of a written statement without any documentary proof cannot be treated as compliance in the true sense. My lord, the offense is punishable with, my lord, only few months with fine, my lord.
Right.
My lord, should I face
the only offense with which for which the petitioner is sought to be prosecuted is under sections 3 is for non-displaying of an abstract of sections 3 and 4 of the Child Labor Prohibition and Regulation Act bracket CLPRA. In the counter affidavit filed, it is contended that there was no proof of delivery of the petitioner's written reply, public compliance report, as contended by the petitioner. Paragraph. The perusal of Annexure 4 shows that it is a typed letter dated 4th December 2012, addressed by the petitioner to the Assistant Labor Officer, Khurda, Bhubaneswar, where it is categorically stated that petitioner neither employs child labor and further states categorically that notice containing the abstract of sections 3 and 4 has been displayed. Paragraph. On the bottom right-hand corner is a rubber stamp of Single Courts Government of Orissa and Court with a signature and date in proof of the said letter having been delivered to the department. Paragraph. The stand taken in the counter affidavit is clearly therefore contrary to the record and is hereby rejected. Paragraph. With the only offense for which the petitioner is being prosecuted concerns not display of the abstract of section 3 and 4 of the CLPRA, and with the petitioner demonstrating that it has in fact displayed the said abstract, the court sees no reason to continue the prosecution against the petitioner. Paragraph. For the aforementioned reasons, complaint petition 2CCC case number 230 of 2013 and the order passed therein on 31st July 2013 by the learned SDJ Bhuvaneshwar are hereby quashed. Petition is disposed.
Last roll matter item 62. 62.
Allow me to raise all the pleas before the.
All right, permitting the petitioner. It's all this.
1 o'clock.
Supplementaries for admission, item number 1.
Not, maybe part. Here, in fact, the petitioner is the review petition is 6 review of an order which is annexed as at annexer 18, page 53. Only on the ground that the submissions which was made during the writ petition, disposal of the writ petition, maybe it was.
There are orders in Supreme Court where you say, I'll withdraw to file a review. But this is not that kind of an order. The order passed with the Supreme Court.
Even where the orders passed by the Honorable Apex Court simply dismissing the SLP also, the Honorable Court has.
No, but this is not that kind of an order.
Yeah, there is a liberty, Lord. Kindly have a glance. No. There is a liberty in the
No, liberty you need to pursue some other remedy.
Turn to page 52.
Page 52.
The Apex Court has held, we decline to interfere in this special petition. You are challenging the order passed by this court dated 23/9/2022.
Yes, I don't.
Right.
Yes.
And if they are not inclined to interfere the same, and the special petition is actually dismissed. The order made confirm.
No.
Then the Lord made a request. As if now we are passing the type of order. However, if any other event is available to the petitioner, he is free to pursue that in accordance with the law. Then how the review is maintained now?
Not even this and the first part of the after
this court made confirm by the Supreme Court, then nothing more to be advocated now in review of this itself.
Lord, kindly have a glance at this judgment at least. This Honorable Court, Apex Court has also come to a conclusion because there is no question of merger because once even after dismissal of this special petition.
There are other matters when it simply says SLP dismissed. All right. This is not that kind of an order. Second, usually you reserve liberty to file a review when review has to be filed.
On the basis of this judgment, of course, I am the Honorable Apex Court. I am because
anyway, what is there in review? Tell us even that. What is there in review?
Yes, well, I am coming to it. Ultimately, my prayer is to only reconsideration by the government. I am not going because the early kindly I am just placing the earlier submission,
which has been closed by the Supreme Court. Now we have to reopen it.
No, kindly
by making no close prayer.
Kindly have a glance at this page 54.
All right,
page 54. Page 54. I'm just placing 2 paragraphs. The order which was passed in the writ petition. Mr. D.P. Swanso, Learned Counsel for the petitioner submits that the petitioner in 2008 made an application to the General Administration Department, Government of Odisha for allotment of the additional land bearing plot number Swanso, which is located behind the petrol pump of the petitioner for the purpose of expansion of the business. Learned Counsel invited attention of this court towards certain photographs of Annexure 15 and submitted that part of the land has been used for construction of small shops for vending zone and another part for establishing garbage dumping area by the Bhubaneswar Development Authority. This land is lying unused. The opposite parties have taken a new plea that the plot in question is reserved for the development of the park by the BDA. However, the BDA has already developed the park elsewhere several years back, leaving the proposed plot. The same has been reiterated in the next paragraph also. As we come to the line after Annexure 14, the land is coming within the area proposed to be developed by the public park by the BDA. Now,
the next line is important, sir.
Yes, important.
You could not produce any material to substantiate the argument that BDA has abandoned the project.
Yes. Yes. Kindly have kindly have a glance at page 51, Annexure 16, which of course I got after the order. Kindly, that is under the Right to Information Act. Page 51. This information has been supplied by the Bhubaneswar Development Authority. With reference to the subject cited above, I am to inform you that there is no proposal as such to make expansion of the existing BDA park, and also no plan to make use of the land lying vacant in between the petrol pump Pokriput and vending zone pertaining to plot number Swanso, Khata number Swanso, Pokriput, Bhubaneswar.
Mr. Mali, this was part of our SLP?
No, this was not.
No, later.
This was not.
Later.
This is 5th November 20.
Yes, this is subsequent.
No, but before the SLP was dismissed.
Yes, before that it was dismissed. Before that it was dismissed. I don't dispute all the facts.
So anyway, with liberty granted by the Supreme Court, you pursue some other remedy. If you want to again write to the government, write it. You quote the Supreme Court order and write to the government.
Let that observation at least be there.
No, why should, this is like unnecessarily, adding to more problems.
Because unless
Once the Supreme Court has said something, nobody should say anything more than that. That's a rule. You say the court has perused the order dated 16th December 2020, passed with the Supreme Court of India in SLP Civil number 14507 of 2020, by which the SLP against this court's order dated 23rd September 2020 was dismissed. Full stop. The said order reads as under, reproduce the order. Mr. Manthi, learned counsel for the review petitioner, urges that notwithstanding the above order, he can still maintain the present review petition. Full stop. The court is not inclined to agree with the submission. Paragraph. Nevertheless, the court has also examined the review petition on merits and finds no ground made out for review of the order dated 23rd September 2020. The review petition is accordingly dismissed.
In this case, my lord, conviction under section 302 and 34 IPC, my lord. Co-convict has already been granted by this court. Another appeal connector will come here, my lord. That is petitioner in custody, my lord, more than 9 years, 2 months, my lord. Thrice he has released on furlough, my lord. Furlough, my lord. Not my lord, misused liberty, my lord. And surrender before the court, and subsequently the jail authority given a certificate, the best volunteer of a cleanliness, my lord, jail. And they taken their lordship, 9 years custody, 9 years, 2 months.
9 years.
2 months.
All right. So the application is perused. The submissions of Mr. Ragada have been heard, as well as Mr. Katkia. The applicant has served over 9 years in custody. Stop. Mr. Ragada also has placed before the court documents to show that the applicant was released on furlough on 2 occasions.
3 occasions.
3 occasions and did not misuse the liberty. Keeping in view the decision of Supreme Court in Singada Singh, and considering that the appeal is in its normal course, not likely to be heard at an early date, the applicant is directed to be released on bail subject to the satisfaction of the time. The application is disposed of. All right. Oh, right. Right. Namaskar, sir. Namaskar.
Supplemental list for orders, item number 1.
May I please, Your Lordship? I am for the petitioner.
Yes.
Your Lordship, order was passed in the year 2012. 11 years passed. The order was not implemented. The reason is that review.
Where is Mr. Matthews is here? All right.
Yes.
1 minute, sir. Let me ask.
My lords, as far as the order of 12th October 2012, the directions were to repost him as placement officer, which was so done after the order was passed.
and to also consider his claim for appointment of head of department, which was not done. We considered it. He was not made head of the department. Now, pursuant to this order, we posted him as a placement officer and also paid him in the reader's scale. This is beyond doubt. Now, what my learned friend seeks through the court, through this IA 282, is an additional benefit of an enhanced scale, what we know as reader plus 5. Now, he says he's entitled to this as per the UGC scale of pay rules. Now, he has annexed a letter from the governor's office, who's our chancellor, and the governor has approved of this proposal to grant him this enhanced pay. There's just one problem. We have written to the governor, sought clarification, saying that under the rules, it says he had to be strictly recruited in accordance with UGC regulations. And my lords, when my lords had dismissed the review petition, I pointed out that, the UGC had never approved of this post as a placement officer.
But now that anyway, the judgment is there.
Yes,
So,
my lord. But now, as far as the rules, if my lords would just have a look at the rules.
But right now at this stage, the contempt, how can we just go back? We can't just revisit the order.
Very well. Then in that case, my lords, I appreciate what has fallen. Then if my lords give the university 2 months' time, we'll make the payment.
All right.
2 months.
Mr. Matthews appearing for the Utkal University states that in 2 months' time, the payment of the differential amount will be made to the petitioner.
As per Annexure 4.
As per Annexure 4.
My lord.
The said statement is placed on record. List this application on, we'll have it in the opening.
Very well.
30th June.
Very well.
30th June.
Retired fellow, retired professor, he's not getting your lordship gratuity.
Move as fast as
Sir, 30th June, I'm saying, sir.
Oblige your lordship.
Oblige.
Right. Right. Oh, right.